Hello, everyone. Welcome to the Independent Contractors and OHS Compliant, the Case of Pike River Coal Mine webinar. This webinar is part of our Return to Work, Stay at Work series, and we're glad to have you here with us today. My name is Tanya Hyde, and I'll be moderating the webinar today. I'm the project manager with the Canadian Institute for the Relief of Pain and Disabilities, and this webinar is made possible through the support of the Community Grants Program through the BC government, as well as through donations and memberships. As I mentioned, my name is Tanya, and I'll be moderating this session and handling the Q&A. And our speaker today is Dr. Felicity Lamm. Dr. Lamm is co-director of the Center for Occupational Health and Safety Research at AUT. As a researcher in the area of OHS for over 25 years, she has written extensively in areas such as regulating and complying with OHS law in the small business sector. She has also been involved in a number of government committees and inquiries, including the recent Independent Task Force on Workplace Health and Safety. Thank you for being with us, Dr. Lamm, and I will hand it over to you now.
Thanks, Tanya. I'd just like to thank Tanya and Lisa and the team at the Canadian Institute for Relief of Pain and Disability for making this webinar possible. This is an exciting opportunity. In my presentation today, I will be looking at the prevalent use of contractors and what this means in terms of occupational health and safety. In particular, this presentation will cover why the topic and the case study are important, what is the role of contractors, particularly in times of disasters, and what are the differences between a contractor and an employee with reference to occupational health and safety. We will also look at the rise of the contractor, including the independent contractor. Here we're going to touch on the changing nature of work and the impact this has had on the health and safety of workers. We will also highlight a couple of useful models to help explain how the changing nature of work impacts on health and safety and of contracted workers. To illustrate the health and safety issues of these workers, we will look at the subcontractors at Pike River Coal Mine, and in particular the failures at the mine, including the mismanagement of the contractors. And finally, we will look at some of the lessons we can learn from the case study and the current literature. So why is this topic important? Well, on November the 19th, 2010, a series of methane gas explosions occurred at Pike River Coal Mine, which is situated outside a small west coast town of Greymouth in New Zealand. It is thought that the 29 workers were actually killed in the first explosion. Unfortunately, chance had a big part to play who was underground when the first explosion occurred, as it was right at the time of the change of the shift. Even though it is tradition that all miners tag in when going into the mine and tag out when leaving the mine, there was utter confusion as to how many workers were trapped underground days after the explosion. There was also a lack of coherent rescue strategy and an inexperienced incident team, all of which served to undermine the hope of any hope of retrieving the workers, dead or alive. This confusion occurred in part due to Pike River Coal Mine subcontracting practices and poor record keeping regarding the whereabouts of the contracted workers. It is important to note that 13 of the dead men worked for subcontracting firms and not for Pike River Coal Mine. At the time of the explosion, out of a workforce of approximately 200, there were over 80 subcontracted workers who worked at the mine. Most of the subcontracted workers were either sole traders or operated local small businesses, employing on average less than 10 people. The local businesses were dependent on Pike River Coal Mine to a less or greater degree. There has also been other disasters where subcontractors, or independent contractors as they are called, have either been at the root cause of the disaster or have been called in to help clear up the mess after a disaster. It is important to note that contractors play two different roles depending on what they were contracted to do and the level of control they had to complete the work. Upstream contractors from large organisations like Halliburton, Valley Long Haul, play a critical role and their actions or inactions are often the major cause of disasters. On the other hand, downstream contractors play a less critical role and often have little or no control over what, when, and how they carry out the work. These contractors are often treated as employees, and yet they have no security either in pay or work, and they are the victims of circumstances. Examples of critical role that subcontractors have played in disasters are the Challenger, Columbia, Deepwater Horizon, and the recent Canadian rail disaster, Lac Mégantic, just to name a few. As the diagram shows, there are common features in disasters when subcontracting labour, and these main features are also the themes throughout this presentation. They are equipment failure or damage controlled by contractors. In the Challenger, it was the O-rings. In the Columbia, it was the faulty foam. Deepwater Horizon, the defective cement. And in Pike River, it was the lack of ventilation. All the disasters mentioned had costly delays and pressure to get the job done. The organisations were also incredibly dysfunctional, complex with poor management systems. Poor decisions were made long before the disaster. For example, in the New Zealand government in the 1990s decided to disband the Mines Inspectorate, and as such at the time of the Pike River Coal Mine disaster, there was only one experienced mine inspector. Moreover, these and other case studies are an important illustration of the rapid recent growth in outsourcing to contractors, whose employment status has been transformed from that of an employee working on a full-time basis to a contracted worker engaged in precarious, dangerous, and often demeaning employment. These workers are typically not covered under any of the protective employment or occupational health and safety regulations, and yet they're often treated in effect as de facto employees. Such workers are more than likely than not to be excluded from obtaining workers' compensation for work-related injuries, either because their employment status and or the inability to determine the cause of injury because of the precarious and fluid nature of their work. Central to this increased use of contractors is the recognition that organisations are now constructed in such a way that so-called peripheral workers now constitute a significant proportion of the workforce. While this relationship might suit both the principal organisation and its contracting workforce in times of certainty, the Pike River Coal Mine disaster shows that this relationship can rapidly turn toxic in catastrophic times, affecting more than just the contractors and their workforce, but also their families and their wider communities. The case study also highlights the fact that there has been a substantial rise in the number of small businesses in most advanced market economies. From an occupational health and safety perspective, this trend is particularly concerning, as there is growing evidence that those working in small businesses are more frequently exposed to dangerous situations and suffer more work-related injuries and illnesses than those working in large businesses. However, before we proceed to examine the Pike River Coal Mine disaster in detail, it is important to visit the debates concerning the differences between a contractor versus an employee. The aim here is to shift our focus in occupational health and safety from the employee to the contractor, who is just as inextricably linked to the principal as any employee, including being reliant on the principal for their livelihood, and yet enjoying fewer rights under the health and safety and employment laws. So, in New Zealand and elsewhere, there are key legal distinctions between a contract of services, that is hiring an employee, and a contract for services, that is hiring a contractor, as we can see in Table 2. For example, in New Zealand, employees are defined under sections of the Employment Relations Act, while the subcontractors denoted in New Zealand law as dependent contractors, are defined as not being employees, and as a result they are instead subject to commercial law and common law rules. This means that the contractor may do the same task as an employee, but his or her legal status is different from that of an employee. So who actually benefits? By hiring contractors, the employer reduces the level of compliance cost imposed by occupational health and safety and employment law. As this slide shows, there are a certain amount of independence being a contractor, yet determining whether a worker is a contractor or an employee can be very difficult. The issue is often litigated, and various courts can decide the issue quite differently. I'll give you an example. In New Zealand, the case Bryson versus 3 Foot 6 Limited, the Employment Relations Authority decided Mr. Bryson was a contractor, but the Employment Court and the Supreme Court decided Mr. Bryson was in fact an employee. In many respects, employment law has developed by governments to protect workers who toiled at the lower and less powerful levels of the organisational hierarchy. In New Zealand, contractors are not entitled to receive so-called minimum statutory protections, such as holiday and other types of paid leave, minimum wages, or even equal pay. Certain implied terms are present in every employment agreement by statute or common law, are not present in ordinary contracts. Contractors do, however, retain some protections, including the rights to a healthy and safe workplace in a number of jurisdictions. There is also an obligation of good faith embedded not only in employment laws but also in contract laws, which requires the parties to be open and communicative and not to do anything that is misleading or deceptive. They also retain the rights and protections under general contract law. These rights, however, do not equate to those defined in employment laws designed to protect employees from what the New Zealand Employment Relations Act calls the inherent inequity of bargaining power in employment relationships. Notwithstanding, contractors can also have their contractors terminated under the terms of the contract without any justification. In the New Zealand context, contractors do not have access to the lower level, low-cost disputes resolution services provided under the employment framework, such as mediation services and the Employment Relations Authority. So what about health and safety, and how does this relate to contractors? While it has been difficult to distinguish between an employee and a contractor in recent years, the blurring of these terms has been part of the wider discourse on outsourcing and the shift from the secure work to insecure work, which are now very important factors within mainstream occupational health and safety literature. As mentioned earlier, the experience of an increasing number of workers employed within structured networks of production and services is the downsizing of large organisations and outsourcing of their work. In turn has resulted in a pattern of displacement of more stable contracts of employment in large organisations. As a result of these structured changes to production and services, there has been a proliferation of small subcontracting businesses, whereby these contractors are reliant for their income on outsourced work from larger businesses. As outlined in David Will's book, The Fissured Workplace, large corporations have shed their role as direct employers of people responsible for their products and services in favour of outsourcing work to small companies that compete fiercely with one another. The result has been the declining wages, eroding benefits, inadequate health and safety conditions, and ever-widening income inequality. According to Weil, from the perspectives of CEOs and investors, fissuring, that is splitting off the functions that were once managed internally, has been a very successful business strategy. allowing companies to become more streamlined and drive down costs. Despite giving up direct control to subcontractors, vendors, and franchisees, these large organizations have figured out how to maintain quality standards and protect the reputation of the brand. They produce brand name products and services without the cost of maintaining an expensive workforce. But from the perspective of the workers, this lucrative strategy has meant poor health and safety outcomes, the stagnation in wages and benefits, and a lower standard of living, if they're fortunate enough to have a job at all. For many contractors, the reality is that they are in fact dependent contractors as opposed to independent contractors. This is particularly so for self-employed workers hired as contractors by a single client who have little control over their work and few, if any, control over their paying conditions. As Professor Arthurs from York University, Canada notes, they are dependent economically, although legally contractors. The ambiguity, the paradox of their position is thus reflected in the term used to identify them. Self-employed, truck drivers, peddlers, taxi cab operators, farmers, fishermen, and service station lessees personify the dependent contractor. Studies of wages and conditions of dependent contractors indicate the working conditions and pay are often exploitative compared to contractors who are not reliant on one client. It is also argued that the effects of subcontracting and outsourcing work to small subcontracting businesses will in certain instances lower occupational health and safety standards within these businesses because of the following reasons. 1. Employment status of both the contractor and the employees is fluid or ambiguous. 2. The nature of skill or work involved is typically hazardous. And 3. The remuneration is likely to be based on output. In research conducted by myself and my good colleagues over the past 2 decades, we have found that a growing number of workers have been coerced into contracting situations, typically by their employer, resulting in a loss of significant remuneration and any semblance of job security, while assuming significant additional safety, health, and financial risks. There is also a substantial body of evidence that shows that the effects of insecure work, whether it is through subcontracting or not, is pervasive and overwhelmingly negative. Like outsourcing, insecure work is at the center of reframing full-time permanent work into precarious employment, such as temporary, seasonal, casual, labour hire, and fixed-term employment. Yet both forms of work are increasingly being adopted for cost-cutting reasons and shifting the risk from the principal employer to the subcontractor. There is a great deal of empirical and conceptualization of work, insecure work and outsourcing has in fact used occupational factors of vulnerability as the focal point. In particular, studies have begun to establish a link between work-related injuries and illnesses suffered by workers and the interconnected social, economic, and political factors. For example, in the Work Health Organization's Employment Conditions Knowledge Network report, they highlight a number of factors that help to explain disparities in work conditions among vulnerable workers. These include employment status conditions of recruitment, sector employment or occupation, employment in the informal sector, lack of freedom of association and collective bargainings. The Australian Michael Quinnan and Philip Bolle have advanced this research further by using health and safety factors to measure and describe vulnerability among groups of workers. In their pressures, disorganization and regulatory failure model, Michael Quinnan and Philip Bolle group a number of factors that have a negative impact on the health and safety of precarious workers, including dependent contractors, into 3 categories: the economic and reward pressures, disorganization and workplace, and regulatory factors. regulatory failures. In the first category entails employment and income insecurity, as well as intense competition for work, which in turn can contribute to a range of hazardous practices, including work intensification, working when injured, and holding multiple jobs. The second category, disorganization, concerns the lack of commitment by businesses to invest in a stable workforce. Here, disorganization is not simply as a result of employers' oversight, but instead it is a characteristic feature of the relationship between contingent workers and their employers. As noted by Elsa Hunderhill and Michael Quinnan, where workforce instability prevents the sustaining of established rules, procedures and roles, then occupational health and safety knowledge and management systems become fractured, whilst inter-worker communication, task coordination and lines of management control are weakened. Underqualified, undertrained, inexperienced workers become more commonplace. In this setting, contingent workers are less able to collectively organise or be heard in the workplace. The use of temporary workers affects employer attitudes to induction training, participation in workplace committees and other activities with implications for health and safety. In the third and final category in this model is regulatory failure, which refers to the extent to which occupational health and safety and employment legislation is weakened by precarious employment arrangements. It is argued here that employment protection and minimum entitlements become ineffectual when vulnerable workers are less cognizant of their entitlements and their employers are less inclined to comply. The occupational health and safety regulatory inspectors also encounter difficulties, such as identifying those with legal responsibility in multi-employer work sites, for example in construction. I think the PDF model mentioned previously not only offers useful insights into the factors that have a negative impact on occupational health and safety of precarious workers, but it also provides the essential theoretical underpinnings for Michael Quinnan's newly released book, 10 Pathways to Death Disaster, Learning from Fatal Incidences in Mines and Other High-Hazard Workplaces. Michael Quinnan provides a critical and long overdue nexus between the patterns of failure in safety and health, precariously employed and vulnerable workers, and disasters. He first examines how and why fatal catastrophic incidences occur in mines and other workplaces, and then how this problem can be addressed both in the immediate and practical sense, and also in terms of a broader reshaping of work organisation, regulation and socio-economic policy. Based on the evidence from selected disasters, including Pike River Coal Mine, as well as drawing from decades of experience in occupational health and safety, Michael Quinnan has identified 10 reoccurring pattern causes. The vast majority of disasters entailed at least 3 of these pattern causes, and many others exhibited 5 or more. These pattern are as follows: engineering and design and maintenance flaws, failure to heed warning signs, flaws in risk management, risk assessment, systems auditing, economic reward pressures compromising safety, failures in regulatory oversight, worker supervision concerns were ignored, poor worker management communication and trust, and flaws in the emergency and rescue procedures. It can be argued, therefore, that subcontracted labour can be considered vulnerable in terms of pay, conditions, and health and safety, as well as tenure. There is also mounting evidence as to why there are poor health and safety outcomes for those who are precariously employed. Furthermore, Michael Quinnan's recurring pattern causes of disasters are indicative of an unsafe and unhealthy working environment in which subcontracted labour operates. What is not clear, however, is the impact of disasters such as Pike River Coal Mine on subcontracted labour, And it is this question that we're going to explore next. The occupational health and safety research on contractors involved in disasters has traditionally viewed them as part of the solution rather than victims of circumstances. However, as a result of the higher rates of disease, chronic injuries and morbidity among contractors involved in disasters such as 9/11 terrorist attacks, Choco earthquake in Japan, and the Canterbury earthquakes in New Zealand, there has been an increasing interest in their welfare post-disaster and the welfare of their family and community. As part of the research agenda on this topic, a team of occupational health and safety researchers in Australia and New Zealand are investigating the impact of work-related injuries and illnesses, in particular the traumatic work-related death, on the victims' families. It is argued that, and I quote, serious illness, injury or death at work has a cascading psychological, social and economic effects on the victims' families and close friends. These effects have been neglected by researchers and policymakers. The number of persons immediately affected by the workplace death is significant, even in rich countries, with relatively low rates of workplace fatality. However, how employers, trade unions and government agencies deal with families following a workplace death is poorly understood. In short, a traumatic work-related death, punctuated by financial and health problems, can dramatically change family relationships, recalibrate family roles and structure, and disrupt friendships. New Zealand research also suggests that an injury to an owner or a key staff member can have a significant impact on the viability of a small business, including a small contracting business. Based on workers' compensation claims, it has been estimated that over 1,800 New Zealand businesses ceased to operate between the years 2002 and 2003 as a direct result of an injury to an owner or employee. A latest survey undertaken on behalf of New Zealand's Accident Compensation Corporation, it was revealed that 58% of the respondents stated that the closure of their small business was a direct result of either the owner or employee being injured, while 19% that an injury to a member of the business was to some extent responsible for business closure. When those respondents who had been injured were asked if they were likely to work in the future, 56% said no, while 8% said they were not sure. Previous research on the impact of multiple work-related fatalities on individuals, businesses and communities provides a number of insights that in turn can be applied to the Pike River Coal Mine case study. While there is yet no complete data analysis on the social consequences and economic costs of the Pike River Coal Mine disaster on the local community, we can speculate that such a disaster has had an enormous impact on Greymouth and the surrounding district. Many of the Greymouth's working population, approximately 1,500, are small businesses employing approximately 7,000 employees, and they support the local mining industry to a large extent. Workers in the Greymouth district are 57 times more likely to be employed by a coal mine than they are in the rest of the country. Therefore, the closure of Pike River Coal Mine and other subsequent mine closures, including Spring Creek, have had an enormous detrimental impact on the level of employment and the local economy. The Greymouth district is not only highly dependent on the mining and other extractive industries such as forestry, but is also dependent on tourism, which has already been disrupted by the influx of specialists to help the rescue and recovery mission, as well as the negative media. As stated previously, out of a workforce of 200, there was over 80 subcontractors employed at the mine at the time of the Pike River Coal Mine explosion. And out of the 29 workers killed, 13 were contracted workers. Pike River Coal Mine Limited not only subcontracted manual labour, both skilled and unskilled, but the company also outsourced most aspects of the mine, including mine design, financial and environmental risk assessment, occupational health and safety planning and engineering, including the mine and ventilation design. The company also used a number of contractors to support mining operations above and below the ground. Pike River Coal Mine's subcontracting bill was understood to be worth about $80 million a year, while its wage bill was understood to be about $13 million a year. To date, 43 contractors are currently owed almost $5 million by Pike River Coal Mine, and a number of them have gone into receivership. There are a number of occupational health and safety failures over the use of contractors in the Pike River Coal Mine, and we're going to start to list some of them. The first one was the mismanagement of the contractors. By mid-2010, the mining company had begun to engage contractors on a one-hour contracts, which meant that contractors were going in and out of the mine on an hourly basis. The part-time, three-man project team, themselves contractors, tried desperately to manage the day-to-day work of the small contractors while doing their own normal jobs, but this was an impossible task. Although the project team had a weekly plan that included information on where contractors would likely be working each day, there was no actual system to keep track of them on an hourly basis once they were underground. You see, contractors were not restricted from moving around the mine. They pretty much had to look after themselves. Moreover, the system of signing in and out of the site often didn't occur, and as a result, neither the control room staff nor the supervisors had any idea of the whereabouts of most contractors. This was not surprising, therefore, that there was total confusion as to who was actually trapped in the mine days after the explosion. Central to the mismanagement of contractors was the production over safety attitude of the management. The Royal Commission of Inquiry noted that large bonuses were offered for increased production, with little or no regard for what this meant for safety for those working in the mine. And number two, the lack of relevant experience. The other problem was that most of the contractors were not miners by trade and had never ever worked underground in a mine before. Moreover, senior and middle management had little or no mining experience either, and if they had mining experience, it was in open cast mining, not underground gaseous mines. This lack of knowledge and experience was to have fatal consequences. On the advice of subcontracted engineers, the company decided to place the main ventilation fan underground, which was unprecedented in any other gaseous mines anywhere in the world. The Royal Commission Inquiry report stated that putting the fan underground was a major error. The decision was neither adequately risk assessed nor did it receive adequate board consideration. As a result of the inadequate ventilation, the incorrect electrical cabling, all of which were undertaken by large subcontracting businesses, there was a dangerous buildup of methane gas which created the perfect combination for an explosion. Number three, lack of occupational health and safety training. The Royal Commission of Inquiry report revealed that the three-man project team were not informed of the Pike River Coal Mine's health and safety policies and procedures and had not completed any documentation as to who was going down the mine and what they were doing. As a result, many of the contractors had staff working underground at Pike River Mine coal without their own occupational health and safety system in place and without alternative protection of having their staff inducted to Pike's health and safety system. Number four, the lack of safety audits. Because there was an absence of an effective safety management system for contractors and their staff, there was also no auditing of contractor safety procedures and performance, no supervision of contractors underground at all. Although Pike's safety management system required regular audits of contract safety performance, there was no evidence that Pike River's managers audited either McConnell or Valley Longhorn, two of the largest contractors, or any of the smaller contractors who lost men on the 19th of November. As a result of this omission, the company was missing vital information on its contractors and the hazards that their staff and or equipment might have introduced into the mine. Furthermore, there was no formal system requiring supervisors to regularly check the safety of the contractors while working underground. That is, it was left to the discretion of the contractors to check their areas of responsibility within the mine. Finally, the lack of enforcement. In line with government policies aimed at introducing flexibility and inefficiencies into the market and a rollback of the state from the 1980s onwards, the actual number of OHS inspectors was reduced dramatically. The change of a workplace in New Zealand, for example, the chance of a workplace being visited by an inspector in New Zealand is therefore highly unlikely, given that there are approximately 150 OHS inspectors covering more than 500,000 businesses and over 2 million employees. In the case of the mining industry in 2009, there were 21 mines, 5 of which were underground, employing over 130 workers, and yet there was only 2 mine inspectors. And by 2011, there was only 1 mine inspector for the whole of New Zealand. So what lessons can we learn? I think that the former safety and training manager for Pike River Coal Mine, Neville Rockhouse, says it all. His statement also indirectly implicates the company's management system, including the use of subcontracted workers, in contributing to the disaster. He states that it never goes away. It's with you every day. It has been an emotional 2.5 years, and I don't think any Kiwi has not been touched by this disaster in some way or form. Mistakes were made on the project, and no one can learn from those mistakes until you first acknowledge that you've made some. And that's the first step in this thing ever happening again in this country. I'm quite embarrassed having to be a miner at Pike River. So the lessons that we can learn from this case study and the literature are as follows. Number 1, the proliferation in complex contracting arrangements. Most of us will be in insecure work at some time in our working lives. Indeed, contractors are now an integral part of most organisations, undertaking essential work in pretty much every sector, from health to transport, from education to construction. Contractors also play multiple roles, operating within a web of complex relationships in most contemporary work sites. One of the reasons why there has been a rise in the number of contracted workers is the outsourcing of occupational health and safety responsibility to others. That is, passing it down the line, if you like. Number 2, vulnerability in contracting. As more people find themselves working in non-traditional contracted jobs and dependent for their livelihood on just one principle, there is a likelihood that they too will experience a level of vulnerability and compromised occupational health and safety. What is clear is that there is little protection for these workers. That is, legislators have placed restrictions on the firm in terms of how and under what conditions employees can be employed, and yet these same restrictions are not transferred to contractors. The consequences of this non-transference of protection can at times be tragic, particularly under poor management structures, as exemplified by the Pike River Coal Mine case study. Number 3, how we manage these complex relationships is challenging but not impossible. There are plenty of examples where organisations with the support from regulatory agencies manage multiple contractors. The more sophisticated models, as documented by David Wheel in 2014, combine the benefits of a private monitoring with the virtues of a public enforcement system. For example, the Department of Labor Wage and Hourly Division in the US uses its power to interrupt the flow of goods from manufacturers to retailers, and as a means of putting pressure on private manufacturing middle-level companies to to monitor their network of subcontractors. However, simple models comprise of all contracted workers being part of health and safety training and engagement together with robust systems as the bedrock of any good occupational health and safety systems. And it is these lessons that I think we can take forward and start opening up the discussion. Thank you for listening, and I welcome questions.
Wonderful. Thank you very much, Dr. Lamm. There was one question. Are there any jurisdictions that have legislated requirements where contracted workers must have the same OHS standards as employees with the same WCB coverage?
It's very interesting because at the moment a lot of the countries that have adopted the Robins model, like the UK, Australia, even Canada and New Zealand, this is part of the law that a lot of them are looking at now. In Australia, they've just had a reform of their occupational health and safety legislation, as have we. And within those jurisdictions and those regulatory frameworks, they have now increased the protection of subcontracted workers, plus they've increased the responsibility for the principal. So in many of the earlier pieces of legislation in a lot of the Commonwealth countries, they not excluded, but the principal was able to offload a lot of those responsibilities without a duty of care. But those areas have now been tightened considerably in the new pieces of legislation that have been passed recently.
Very good. We don't have any other questions at this moment. For those of you online, please do submit your question if you have any. For Dr. Lamm.
May I just perhaps say a few things about Pike River and just sort of give some context to it. Very interestingly, I actually happened to be going down to the west coast where the Pike River mine was situated with Michael Quinnan, who just had finished the Beaconsfield inquiry. And when we were going through a particular narrow gorge and where a lot of logging trucks had gone through, and we noticed that a lot of police cars and emergency services were passing us at great speed. Now, we naturally assumed that it would have been a logging truck that had gone through, but in fact it was Pike River Coal Mine that had blown up. But there was, as I said in my talk, that a lot of us had no idea how many people were down there, what the status was, etc. And what had also transpired is that the utter failings of the Pike River Coal Mine that was set up as sort of the best practice of mining safety. They had virtually no egress in times of emergency. Their ventilation masks, etc., were faulty, and it just goes on. The Royal Commission of Inquiry makes very depressing reading.
All right, and then we do have another question. There's some further ways to strengthen the new Commonwealth legislation. What remains as weaknesses?
I still think that the rights of contractors to have access to the most basic employment protections, like equal pay, like work participation, like training. And I think that not only jurisdictions can strengthen those pieces of legislation, those parts of the legislation that pertain to contracted workers, but also I think as a community of occupational health and safety researchers and practitioners, we need to also include them into the fold. For so many years, for decades, we've only concentrated on employees, but increasingly these workers are treated as employees. They're de facto employees. And when you look at the situation, say, for example, in Japan, the cleanup of toxic waste from the earthquakes and the nuclear power plants, from the Christchurch earthquakes, etc. A lot of these are extremely vulnerable and very rarely do they have a clear run to get access to workers' compensation. Most of their claims for workers' compensation are extremely complex and difficult to achieve, if at all.